I've been able to talk, by the way.
Okay, well, welcome to our fourth lecture covering Module 2. This is our second PowerPoint presentation for Module 2, and you can see that the title here is Introduction to Employment Law. At this point, we've kind of been warming up to our topic, and that is employment law. We've kind of dabbled with a few concepts to get our bearings so we can process the bigger picture, what the meat of the course is about, and now we're ready to start having that. So we're done with the appetizers, we're ready for the main course. So let's begin. This module is broken down into 6 parts. We're going to do a very brief overview of the history. Then we're going to talk about procedures for enforcing employment laws. We'll talk briefly about arbitration agreements, when they can be used and when they can't be used. And finally, we'll talk about legal remedies. We'll save the last 2 topics for a later lecture. So let's begin. So we're going to talk about the history of labor and employment law, and the order here is pretty important because most of the laws we talk about, or the oldest laws we're going to talk about are labor laws, and the more recent laws that we're going to talk about are employment laws. So we start with labor, we end with employment. Let's begin. Let's kind of go back a long time in history and talk about the common law. And of course, our legal system began in England, and our first ideas about how to look at employment relationships come from England and come from a society that was agrarian. And so ideas like employment at will and things like that came from a particular institutional way of organizing labor. And so that's kind of the backdrop from this. Prior to the 20th century, there was almost no employment law that existed, or labor law for that matter. It wasn't an area that was really regulated at all, and when it was regulated, it would have been regulated, there would have been court cases based upon contract law. We don't start seeing the first types of employment related law until we see the first workers' compensation statutes. And we'll talk about workers' compensation in a later module. But that was kind of our first effort as a society to dabble with workplace protections. And probably our next effort to dabble in that area was the National Labor Relations Act. And that was during, of course, the Great Depression, when times were so very difficult, and there was an effort to help workers retain employment when that was possible. At around that time, we also had the Fair Labor Standards Act, which established a minimum wage and overtime pay. Of course, the purpose of overtime pay we see differently than they would have seen. In this first slide, I said, the past is a foreign country. They do things differently there. We probably, or many of us think of overtime pay as kind of an extra reward for being especially diligent. But that's not how people in the 1930s would have seen it at all. It was a way to encourage employers to increase their workforce. It used to be, until overtime pay was required, is that employers would just keep that same number of workers and work those workers for more hours. But once it became more expensive to work them beyond 40 hours, there was an incentive for that employer to hire more people. That was the real reason why the FLSA was passed, at least the part of the law that related to overtime pay, because there was tremendous unemployment in the country, and this was a mechanism to encourage employers to increase employment. We don't see it that way because, again, we're living in a foreign country compared to the times back then. It's always interesting when we look at historical things to kind of unpack it. We see it through our lens, and yet many times the way that people at that time would have seen the issue is very different than how we would have seen the issue. As we can see through most of these movements, these laws became law not so much from a top-down approach, but because the workers themselves were agitating and politicking and protesting to get these changes done. The workers' compensation laws didn't happen just because some politicians thought it was a good idea. It was because the workers themselves recognized the importance of this for their own lives. And so usually these come from social movements, and it's from the bottom up that we see these activities go forward. Here's a list of various laws and the various times where they became law. This is not an exhaustive list. You absolutely are not expected to know these dates or even the order that these happened. But we will talk about most of these laws at some point during the course. As I'm looking at the list, I'm not sure we ever talk about the Pension Protection Act, but other than that, I think we probably talk about all of the other laws at some point in the course. So you will know about these laws. You may not know the year or the order, but these are things that are important legal topics. We don't talk about Social Security Act either. But the rest of the laws we do talk about, in many cases at length. So here we go. We've talked a little bit about history. Now we're going to dive into what the nature of employment law is today. So as we said before in previous lectures, employment law is a patchwork of local, state, and federal laws. If we were in California, we would be spending a lot of time talking about state laws. But because we're in Texas, most Texas state laws are going to match or mirror the federal law. And there's relatively few local laws that apply in the private sector in Texas. So while there is this patchwork, in our course, we're going to focus on the federal, simply because we're in the state of Texas. But when there are conflicts or overlap between state and federal law, we will discuss how that plays out in Texas, and we'll also in some cases consider other states' laws, because many times you will find in your practice, especially if you work for a large employer, that you may be needing to be familiar with laws in lots of different states. One issue to think about is who the employee works for. In most cases, the employee is going to work for a private employer, and in that situation, that's a pretty easy scenario to look at. If the employee works for a government entity, then it may be relevant whether it's a federal government entity or a state government entity or a local government entity. And it can also be relevant exactly what function that person has, see if they currently have a property interest. Another issue is whether they are part of a bargaining unit. In other words, there's union representation. Then the third thing that can be important is the size of the employer. As we saw when we were discussing the definition of employer, the number of employees that the employer has can impact whether a particular employer is covered by a particular statute. So these are important threshold questions to consider before you actually analyze. If somebody comes to you and says, I think that we might have a discrimination claim, and you discover they only have 10 employees, you're probably going to respond that there isn't a legal risk for the company, even though you may want to advise them that that's probably not a good business judgment to discriminate against the employees. Employment law changes, as we can see through the timeline here. There's really not been a decade that there haven't been significant adjustments and changes to the law. And even when there hasn't been a statute that's come down, there have been cases that have changed these laws. In some senses, sometimes the cases change the law so much that it's difficult to recognize the original statute because of the gloss that the courts have put on it. So this is definitely an area of the law that will not be the same 10 years from now as it exists today, and that does mean that practitioners in this area have to keep up to speed. We've talked about primary source of law, but here's just a reminder about what those primary sources can look like and some examples. Now we're going to talk about how we enforce employment laws in our culture, in our country. So let's imagine that you work for ABC company. You feel that you've been the victim of some type of violation of employment laws. Perhaps you're considering going to attorney, perhaps you plan on representing yourself. Your first question may be, how do I get started? There's lots of different paths along this line. One thing that oftentimes can be very productive is to raise the concern internally. Talk to somebody in the HR department, or use an anonymous 1-800 number to lodge a complaint. Talk directly to your supervisor if your supervisor is the source of the problem. Those can be effective methods to solve a problem. And a lot of times if you can solve a problem that way before the animosity maybe gets to a point where it's a difficult situation for everyone, you can oftentimes move forward. But sometimes that doesn't work. You may also be represented by a union. In that situation, you're probably going to want to go to your union steward, who's a representative of the union and also a co-worker, and go to him or her and discuss the concern, and then the union steward can decide whether to file a grievance or whether it's under the terms of the union contract whether the grievance is appropriate. So both of those are somewhat internal mechanisms for resolving the issue, and they can be effective, but sometimes they aren't going to be effective or they're not appropriate to try. I guess the next step would be to go outside the organization. If you were to follow that approach, you would be going to the administrative agency that particularly enforces that law. So let's say I think that I've been the victim of race or sex discrimination. In that situation, I'm going to go to the Equal Employment Opportunity Commission, and I'm going to file a document called a charge. That's called a charge of discrimination. I'm going to tell my story to the investigator, and then I will sign the charge of discrimination. And then that investigator will investigate the allegations that I've made, and he or she will contact my employer and hear the employer's side as well. If I have witnesses or supporting documentation, the investigator will look at that. And so I have to follow that procedure before I can file the lawsuit. If I want to file a lawsuit, this is a necessary first step. Typically, in the state of Texas, I have 300 days from the date of the discriminatory event before I have to file my charge of discrimination. Usually it makes sense to file it as soon as possible, but I may think I can help through these internal mechanisms. But after 300 days, I've probably either concluded that the problem is solved or the problem isn't going to be solved through this mechanism. And so I have the time to go ahead and file a charge. Now you can see, though, that I don't have a whole year even to file a charge. So the statutory period, the statute of limitations, is relatively brief before the time period that I need to file my charge of discrimination. If I miss that deadline, I'm going to be out of luck. I won't be able to file my lawsuit. Once I file my charge of discrimination, then I will, the agency has it, and the agency can immediately issue me what's called a right to sue letter that gives me permission to file my lawsuit, so they can do it immediately. Oftentimes when that happens, it's because I've requested them not to actually investigate my charge, but to give me permission to sue, because again, I need that letter, that right to sue letter, before I can actually file my lawsuit. I've had cases where the letter has issued almost immediately, within days. I've also had situations where the EOC or the state agency has spent years investigating. I had one case that was over 5 years that they investigated a case. And the vast majority of the time, I think it's pretty safe to say, the agency wasn't doing anything with respect to the case. So there's all kinds of extremes and time periods. But whether it's a state agency or the federal agency, once they issue that right to sue notice, and I receive that notice, I, the charging party, I have only 90 days to file my lawsuit. So there are two deadlines I have, the 300-day deadline and the 90-day deadline. If I miss either one of those, I'm going to be out of luck. I will not be able to successfully sue. And they're both hard and fast dates. Now the 300-day deadline, that first deadline, the deadline that I have to use to file my charge, in the state of Texas is 300 days, but in some states it's not that long. It's only 180 days. And these are states that don't have what are called FEP or 704 agencies. An FEP agency is a Fair Employment Practices Agency. It's very similar to the EEOC. In Texas, we do have such an agency. It's called the Texas Workforce Commission. And it performs lots of functions, including payday issues and unemployment issues. But it also investigates discrimination claims just like the EEOC does. And as a result, because we have one of those agencies, the time period that potential charging parties have to file their initial charge, either with the EEOC or with the state agency, is 300 days. Most states have these agencies, but not every state does. I think, for example, the state of Alabama doesn't, and maybe the state of Georgia doesn't. And so in those states, a charging party has only 180 days to file the charge. So the requirement that the charge be filed before the lawsuit can be filed is called the exhaustion of administrative remedies. This concept is not unique to employment law. There are many regulatory areas where a potential litigant has to use the regulatory process before he or she can use the court system. The idea behind that is that many times the problem can be solved by the administrative agency and there's no need to file a lawsuit. My experience probably isn't that the EOC is that successful at resolving the issues. So many times it becomes kind of a check-off thing that the potential plaintiff has to do before he or she can go to the next step in the process. But in theory, it could work. So you may be thinking, the right to sue letter, what's the deal about that? Tell me more about that. Well, once the EOC has concluded its investigation, it reaches a determination, and it can do one of three things. It can conclude that there was discrimination in its opinion. It's based upon its investigation. And it can choose to sue on behalf of the charging party. So it's going to be the charging party's attorney. So that's one path. Another path is it can find that there is evidence of discrimination that's pretty strong. And so it can issue a finding of what's called probable cause. But it can say, we're too busy to actually represent you, but you can use this notice of probable cause and you'll probably be able to find an attorney who'll be able to represent you or interested in representing you under these circumstances. And then the potential claimant goes off and finds an attorney and files his or her lawsuit within those 90 days. The third thing that the EOC can do is issue a finding of no probable cause. That means it didn't find significant evidence that there was any violation of statute, and so it has concluded that there probably wasn't any discrimination. Under all three of these scenarios, the plaintiff is allowed to sue, and the evidence of the probable or no probable cause finding is never shared with the jury. It's a good way for the plaintiff to market himself or herself if he or she has the probable cause finding. So in the first option, the EOC sues on the behalf. The other two options, the EOC doesn't sue on behalf of the plaintiff has to find his own representation. In all three cases, though, they need that letter from the EOC that says that gives the plaintiff the right to sue. It also inherently means that the EOC is patent, or the option number 2 and option number 3 means that the EOC has decided not to pursue the matter. They themselves are not going to prosecute the case. Now you may be thinking to yourself, well, gosh, if I were the plaintiff, I would really want option number 1 because then I get a free attorney. It's the government. That sounds really great. I don't mean to say that the EOC can't do a good job for plaintiffs. Sometimes they do. But most plaintiffs would prefer to have their own attorney represent them. Because when the EOC prosecutes the case, the EOC doesn't have to do what the plaintiff wants to do. But in many cases, the EOC's agenda may be different than, or sometimes in conflict with the plaintiff. For example, most likely what the plaintiff is most interested in is getting money. He or she is usually out of work at this point and has bills to pay and other things that are going on. And so what that person wants more than anything else is money. They may want reinstatement too, so that can be another interest. What the EOC, though, is most interested in isn't money. I mean, that's good. They're not objecting to money, but they want to change the culture in that bad employer's business. They want to come in and require training and require oversight into the practices. And so they are likely to focus on those. It's not that the plaintiff doesn't want the culture in the organization to change, but that doesn't put money in his piggy bank. And so that emphasis is different. And so it may mean that the EOC is willing to settle for less money if they get some of those policy changes. So you can see how the employee may not particularly care for the EOC's involvement. Another reason why plaintiffs often don't like the EOC to represent them is that the EOC doesn't like to settle. The EOC wants to have its day in court. In many, well, I mean, it doesn't mind settling, but it's not focused on settling. If it does settle, what it doesn't want is a confidentiality agreement, because it wants to be able to go to the press and say, look what we were able to achieve. That can be a way that it can persuade the general public that the EOC is an effective agency, because they're saying how much, the press is saying how much money the EOC has gotten. Of course, the flip side is the employer does not want to be on the front page of the Dallas Morning News. And in fact, the employer would be willing to pay probably a pretty significant amount of money to avoid that happening. And so the employee is saying, hey, I don't need publicity, I want money. And if getting a confidentiality agreement gets me an extra $100,000, I'm on board with that. But the EOC is going to say, no, we're not going to agree to a confidentiality agreement. We're either going to try this case to a trial, or we're going to settle it in a way that we can get some good publicity for our agency out of it. So you can see how when the EOC is litigating it, it becomes a lot more complicated. If the employee has his or her own attorney, that attorney is going to do what the employee wants. And so it's quite possible that the employee will get the money quicker and will get more money than if the EOC is managing the case. Again, every case is different, and I'm not saying the EOC doesn't do a good job for these individuals. It's just a situation where there's different motivations. But before the right to sue letter issues, back when we're in the investigation phase, one of the things that will happen is the agency will try to conciliate the case. Conciliation is a legalistic term for trying to settle the case. Usually the investigator will try to get both parties together to talk about the possibilities of settlement. It's a pretty routine part of the process. I haven't had much success in my career with EOC's efforts to conciliate, but in theory it could be effective. The investigators sometimes don't have the skills to be as effective at that as would be ideal. And of course, one of the problems that they often have is that the charging parties don't always have very strong cases. About 95% of all charges of discrimination filed with the EOC dismisses based upon a lack of probable cause. And so that third option, the one where they see that there's no basis for the charge, happens about 95% of the time. And so you can see how an employer isn't going to be very willing to pay much money if, when the employer looks at the facts of the case, there doesn't seem to be a legal basis for the claim that the employee is making. So most statutes require that the employee go through this process. There are a few statutes that don't require the filing of a charge, but it can still be a smart strategy, especially for an individual who hasn't been able to locate an attorney. So for the laws that don't require it, the employee would sue the employer immediately if he or she did not want to use the agency process. So how long does the employee have to begin the process? We've already talked about this, that we have the 300 and the 90 days. Let's talk about the topic of equitable tolling. This is an idea that we see really in every area of the law, because every area of the law has a filing deadline, a date by which you have to file your lawsuit. And so if you are filing before that deadline comes, you're good to go, right? But sometimes things happen, and the date has come and gone, and you didn't file until after that date. So one of the things that plaintiff would want to do in that situation is assert that there's some reason for equitable tolling. So what is equitable tolling? Well, the first part of that is the word equitable. And if you've taken other legal courses, especially intro, you've seen this term before. This is here we go, sorry. It's from the word equity. Remember we talked about the differences between law and equity? So you may recall that when we talked about equity, we said that equity is kind of a loosey-goosey system. It's where the court has a lot of flexibility in applying concepts of fairness and justice without a lot of very technical rules it has to follow. And so that's kind of where we see the equity part. So typically when you have a statute of limitations, the court says, if it's a day late, too bad for you. You're out of luck. We have a hard and fast rule because this is a law. We're not on equity right now. We're on the legal side. This is a law, and you're 1 day late, and I don't really care why you're late. That's your problem. It's not mine. You're a day late. You're out of luck. But on the equity side, the judge is going to say, well, let me hear your story. Maybe you have a good reason. I'm willing to listen. I may not agree. I may not find it compelling enough, but I'm at least willing to consider that. And if the court sitting in equity decides that your reason is, that the actions you took were reasonable under the circumstances, then the court is going to toll or stop the statutory period. It's kind of like everything's frozen in place for that time. The clock continued to go forward, but whenever that bad thing happened to you, the timer on your statutory period stopped advancing. Imagine for a second that you were fired from your job, and the very next day you get hit by a bus, and you're in a coma for 2 years. When you wake up, well, your 300 days have come and gone. And so a court sitting in law would say, oh, I'm sorry, but you only had 300 days to file your charge, and it's been over 2 years, so too bad, so sad for you, you're out of luck. But then you say, but Your Honor, what about equity? Can't you apply equitable tolling? The court would be like, well, okay, tell me about your story. Now I want to hear from the equity side of things. What happened to you that caused you to be delayed? And when you tell the story of you being in a coma, the court's going to say, well, you couldn't really file something when you were, unconscious for 2 years. So from the second you had your car accident or your bus accident, and you were in a coma until you woke up from your coma and had, return your senses to you, I'm going to say that the clock stopped ticking for that time period. And so you still have time on your 300-day clock at that result. Now, equitable tolling is not something courts do lightly. You need to have pretty compelling facts. And so that's why you really do want to stay within the statutory period. You really do want to file by the 300 days, and you certainly want to file your lawsuit by the 90th day. We've talked about how lawsuits can be filed in both in state court or federal court, although federal court for employment matters is the more common place to go. We sometimes see class actions in the area of employment discrimination. The largest class action ever filed in the United States was an employment case. It was Dukes versus Walmart. And Ms. Dukes was the named plaintiff in the class action, and there were over 1 million people, women, I think it was all women, who was asserting age discrimination by Walmart. And the class was seeking class certification. Walmart opposed it, saying each one of these situations is its own fact pattern. For example, the reason why Mrs. Dukes was denied a promotion has to do with her particular work history and all of the specific facts of her store and her skill set and her performance abilities. And there would be a different set of facts with respect to every single person, every single woman who's worked at Walmart. So you can't lump them together and say they're all cookie cutters about each other. And so in that case, Walmart was successful. They were able to say that it really requires an individualized evaluation to see whether Ms. Dukes was really a victim of sex discrimination or not. You would need to look at the facts. You couldn't just say Mrs. Dukes was denied a job. She's a woman. It must be sexism. That doesn't make sense. I mean, it may have been sexism, but it may not be. So it's difficult to apply a class action idea to many types of employment discrimination cases, but there are others where it's quite easy. Imagine that you have a class of workers who all do the same thing every day. Let's say it's an assembly line, and let's say this is an assembly line that makes cars. And all of the workers, before they can get to their work location, their workstation, to screw in that lug nut or tighten that device or whatever their task is, they have to spend at least 20 minutes getting on safety gear, walking from one place to another. And let's say that time is not compensated by the employer. Well, those employees could file a class action under the Fair Labor Standards Act, or the Portal Act specifically, and say, we ought to be paid those 20 minutes. And you can see that would add up. You might have 100 or 1,000 workers in that position, and every day, each one of those workers spends those 20 minutes. And in some cases, that extra 20 minutes might push those workers into an overtime situation, so there might be time and a half involved as well. So if you sit down and do the math for a little while, you can see you might be talking about millions of dollars. And in this situation, you probably don't need an individualized evaluation because all of the workers are doing the same things. Let's say that in order to before they clock in, they have to put on safety goggles that they get from a certain location in the plant, and they have to put on certain gloves and certain footwear. And then they have to walk, a quarter of a mile from one location to another to get another piece of equipment, maybe a bib or something that they, or a hat, a hard hat that they wear. And then they clock in. And while there may be some variation, and maybe some people are going to do it in 18 minutes, or maybe other people are doing it in 22 minutes, but still you can see how you could average out that time to get an approximate value. So there can be situations, especially in the FLSA portal area, where class actions do make a lot of sense. So that's why I say sometimes here. Some areas are you're able to do that, some areas maybe you're not so much able to do that. So let's talk about arbitration. Arbitration is something that we call a source of alternative dispute resolution. There's two main areas of alternative dispute resolution that we're going to focus on in this course. But before we talk about those two, I'm going to mention just in passing a third. And the third is negotiation. I don't list it here because it's kind of a no-brainer, right? Of course the parties are going to discuss the possibility of settlement. The court's going to insist upon them doing it anyway, but even if the court didn't, it just makes good sense to see if there's a way of avoiding the costs and inconveniences of trial by seeing if there's a way to come up with a compromise resolution. So negotiation is an alternative dispute resolution technique, or an ADR technique. But because it's an informal process, I'm not going to count it as one of the two main ones that we're going to be talking about. The first one I'm going to talk about is mediation. And mediation is obviously a defined term here, so be sure to add it to Quizlet. The definition that we're going to use is a process through which a single neutral person, and we're going to call this person a mediator. You probably saw that coming, right? He or she serves as an intermediary between the two parties. He or she is not on either side, and that helps him or her be a person who has credibility with both sides. And so he or she is able to coax and cajole and persuade both sides to maybe step away from unreasonable perspectives. The mediator himself, I don't know why there, sorry about that. The mediator himself or herself can't force a settlement. It's not his money, it's not her money, but he or she can make a recommendation, say this is one way, maybe if we did this, maybe if we did that. Most mediators are attorneys, but they don't have to be attorneys. Certainly paralegals can pursue that area, and you can be in other industries. I've seen cases, particularly in very technical fields, where you've had, instead of legal professionals in that role, you've had people that really understand the science or the medical impact of a particular situation. And so they can have additional credibility with parties in that sense. In Texas and in many states, mediators have to be licensed. And of course, they don't have to be attorneys, but they need to be licensed. Collin College has a mediation program that will prepare you to be licensed. UNT also has such a program. I'm going to be honest with you, though. I think it would be difficult for a non-attorney to make a career out of mediation. Can it be part of your practice as a paralegal? Possibly. I think that's a possibility, but I don't think that you would find that it would be sufficient to support your entire career. Most paralegal mediators are probably not going to be in the employment law area. More likely, they would be in the family law area. A lot of mediations occur in the family law context. In fact, many judges require mediation before a case can go to trial. So there is a lot of mediation activity out there. And courts can't do that. Courts can't force the parties to agree, but they can require that the parties sit down and discuss the matter. So the other arbitration tool that the other ADR tool we're going to talk about is arbitration. So here's another term that we're defining. It's an extrajudicial process. And let's just pause here. When I say extrajudicial, what I mean is it's not part of the court system. So it's an out-of-court process through which the trier of fact is, and this, we're going to call him the arbitrator. So we don't have a jury in this situation. We don't even have a judge, although many arbitrators are retired judges. You can have more than one arbitrator, but certainly the vast majority of times there's just one arbitrator. Anyway, that person is typically experienced in employment law. And he or she may be an attorney or a judge who's practiced in that area. The person doesn't have to be an attorney or judge, but certainly that would be the common path. Again, if it were a very technical field, involving a lot of science or engineering or things like that, you might consider having someone who's not an attorney, especially if it were a panel situation where you had more than one arbitrator. An arbitration proceeds very similarly to a trial. I mean, it's not going to be in a courtroom. It'll probably be in a conference room. It may even be by Zoom these days. But in terms of the process, it's going to feel like a trial. There's going to be someone functioning the role of a judge. There's going to be questions about admissibility of evidence. There's going to be witnesses under oath. There will be subpoenas. There will be objections. There will be motions. There will be a decision that the judge, the arbitrator, issues. So it's going to feel very much like a trial, just in a less formal setting. Arbitration, though, is considered to be pretty significantly less expensive than a trial, in large part because you don't have the expenses associated with the jury. Jury trials require a significant amount more presentation because you're dealing with lay people who don't have a sophisticated understanding of the law. And so the trials take quite a bit longer, and it requires, I guess, more of a psychological element to prepare the case in a way that's going to be compelling to people that don't ordinarily handle these types of cases. In Texas, it is not a requirement that the employer pay all the costs of arbitration, but it's pretty common that the employer will pay the costs. In that sense, the costs of the arbitrator, and basically what you're paying for is the conference room and the cost of the arbitrator. So it's not a huge expense. About a third of all large employers require at least some of its employees to enter into arbitration agreements. This was very popular a decade or two ago. It's become less popular in subsequent years, but still it's a thing that happens. And the idea here is that arbitration is less expensive for the employer, and usually it's a more predictable result because juries, because they're lay people, many times the results can be unexpected and in ways that the parties would have been hard for them to plan for. Arbitration, because it's a legal professional, is a little bit more of a predictable situation. Let's see if I can have a slide about arbitration. Most arbitrations that happen as a result of a mandatory arbitration agreement. And these arbitration agreements are typically entered into when the employee begins his or her employment, or at some point in their career, maybe when they go into management, or they reach a certain level within the organization, or perhaps when the company decides to roll out an arbitration process. Typically, at the time that the employee is presented with the arbitration agreement, he or she isn't given a choice. And well, I guess there is a choice. Either sign or you don't have a position here anymore. That is a lawful option to offer in Texas. And you can imagine, if you're presented with that option, sign on the dotted line or hit the road, Jack, you're going to sign on the dotted line in most cases. Arbitration agreements have to be in writing. And again, it's fine for it to be a condition of employment. The Federal Arbitration Act, the FAA, is a federal law that requires that in most circumstances, federal courts are going to have to enforce, in other words, comply with the terms of most written arbitration agreements. So that means that if the plaintiff and the defendant have an arbitration agreement and the plaintiff still files a lawsuit in federal court, well, that federal judge, and then the defendant brings to the court's attention that there is this arbitration agreement, the court is going to have to dismiss the lawsuit and refer the dispute to the arbitrator. Sometimes some provisions in the arbitration agreement has been found to be unconscionable. Now, this isn't likely to be a very successful argument in Texas. Texas is a very pro-arbitration state. But the concept of unconscionability can come up in other states, and I think it's possible that it could come up even in Texas. The concept of unconscionability generally appears in many areas of law. I guess we probably talk most about it in the context of contract law. So when you are in LGLA 1351, you'll see more information about this. Unconscionability can be broken down into procedural unconscionability and substantive unconscionability. And procedural one, as you can see, it's about the how the contract was entered into. An extreme case of procedural unconscionability would be if I were to present you with a contract written in Serbo-Croatian. You don't read Serbo-Croatian. You say, I can't sign this, I don't read this. Let me hire somebody who speaks Serbo-Croatian. I'm like, no, you have to sign it right now, or the deal is over. But I don't know what it says. Tough, you just got to sign it. That would be an example of procedural unconscionability. It's unfair for me to expect you to sign something when you don't understand it. It might be if you were able to read the document, let's say you did suddenly speak Serbo-Croatian or read Serbo-Croatian, you might read it and go, yeah, this is a very fair document. I do want to sign it. So in this situation, we're not really looking at the underlying elements of the contract. We're just saying the way that it was presented is unfair. Now, obviously, if someone signs under those circumstances and then later complains about it, they probably also think it's somewhat substantively unfair as well. So usually a procedural unconscionability claim has some substantive unconscionability claim associated with it. And this is when the party is saying, this contract is completely one-sided, completely unfair. Now, courts don't like to play nanny. If everybody's an adult and nobody has some kind of dementia or something like that, the court is very reluctant to say, well, that's not fair that you did this, or this contract said this. So what the court's likely to say is, you're a grown-up, you signed on the dotted line, I guess you're pretty stupid. Don't do that again if you don't want to have to accept the consequences. Courts give a lot of tough love in those situations. So the agreement has to be quite lopsided, not just, boy, that doesn't look very fair, but it's just shockingly one-sided before a court's going to say that it's unconscionable. And the same applies in arbitration matters. You're really going to have a contract that feels really unfair before a court's going to consider not enforcing it. And again, in Texas, that's a pretty significant hurdle to overcome. So let's assume that if your client wants to establish an arbitration agreement. Obviously, you're going to want to draft it carefully. And here are some things that you'll want to think about as you're drafting it, some things to avoid so that your client is going to be in pretty safe territory. One thing you're going to want to avoid is you're going to want to make sure that, or I guess you're going to want to make sure that you have a process for selecting the arbitrator, and that the process is fair for both the employer and the employee, and that it really would result in a neutral arbitrator being assigned. You also likely want to avoid the employee having to pay a lot of money, especially money up front. An employee under these circumstances is usually out of work and probably doesn't have the money, and so therefore that can become a bar for him advancing his claims. You also probably want to make sure that the remedies or the awards that the employee could get through the arbitration process ideally should be the same that he or she would have gotten if he or she had advanced the claims in the court system. Offering smaller, for example, precluding punitive damages or attorney's fees, or precluding reinstatement or things like that, are signs that might cause a court to find that the agreement was substantively unconscionable. And throw out the whole agreement, then you're in court, and that's not a good thing to be. You're also going to want to include some type of discovery process. Now, for those of y'all, this is your first semester in the program. Discovery is a process that happens during the court case before trial, where both sides exchange all of the data and information about the case that they've accumulated. And so when they go to trial, both sides knows everything about the other guy's side. We don't have any moments, and the jury may be surprised by evidence, but the plaintiff and the defendant aren't going to be surprised by what's said or not said at trial. And so denying the plaintiff the ability to get that discovery, or at least some discovery before trial, would really put him in a pretty significant disadvantage, because in an employment discrimination case, the employer has all the information, or almost all the information. You want to make sure that whatever restrictions are put on the employer in terms of number of witnesses or amount of time he has to present his case is equally borne between the employee and the employer. And you want an agreement that isn't going to change over time. If you have a clause in it that says the employer can change at any time, very likely the court's not going to enforce it. So here are some things that we've seen cases already say these look pretty unconscionable. So we don't want to have these type of provisions in our agreement. So if you're going to have an agreement, you want to make sure that they are in writing, and you want it to be very clear to the employee that they are waiving their right to sue in a courtroom. In fact, you're probably going to have this in bold, all cap letters in a prominent place in the document, so the employee can't later on say, I didn't understand. You want to have it written in a way that it's easy for a layperson to understand. If you are going to roll this program out to lower level folks, perhaps folks who don't have a college background, or maybe even haven't graduated from high school, then you're going to want to make the language even more simple, because you don't want it to be able to be said, well, I didn't know that word that you wrote there. I thought it meant something. I didn't know what arbitration was. I thought it meant something different than what you say. You want to make sure that the vocabulary and the word length and the sentence length is such that it's easy for somebody of the educational level of the potential plaintiff, he or she would be able to understand it. And of course, you're going to want a signature from the employee indicating that he or she has agreed to these terms. Okay, so now we're going to talk about remedies. This is what the plaintiff is going to get if he or she is successful. The way I remember this is a remedy, in the area of medicine, the remedy is what cures you, right? You take that pill, you feel better. That's the remedy. Well, we have the same thing in the law. The remedy to the plaintiff's problem is whatever the plaintiff is suing for. And usually what the plaintiff is suing for is money. But sometimes in the employment context, the plaintiff may be suing for reinstatement. He or she wants to return to work, and in some sense, that's just another way of saying money, because after all, he or she wants to return to work so he or she can earn money. But that's not, we don't have plaintiffs just saying, I want money. They have to come up with a legal justification for all of the money they seek to recover. So let's look at some of these categories, and we're gonna, I'm going to kind of, actually, let's go to the next couple of slides, and we'll return to some of these in a second. But you'll see many of these items are on the next few slides. So we have back pay. This is the pay that the plaintiff would have earned if his employment had never ended. Back pay stops on the day that the jury has rendered its decision. So let's say Bob was laid off January 1st, 2021, and the trial concludes on January 1st, 2022. So it's been 365 days that Bob has been unemployed. And let's say Bob on average earned $43,000. Well, that would be his amount of back pay. It's not like he would have retired on January 1st, 2022. He would have continued to earn money. But that isn't back pay anymore. That's front pay. That would be money that he would be awarded based upon the projection that he won't be employed by the company going forward. Okay, so back pay is a little bit tricky though, because the plaintiff has the duty to mitigate his damages. He has the duty to make his damages as small as possible. So when Bob was laid off, it was his responsibility to try to find alternative employment. And if he failed to find alternative employment, meaning he didn't try to find alternative employment, then he's not going to be awarded back pay, because that was his obligation. Now, if he tried conscientiously but just wasn't successful, then he would be entitled to back pay. Let's assume that he was successful at getting a job, but he couldn't get a job where he earned $43,000. He just earned $37,000. Well, his amount of back pay would be the difference, $5,000. That's how the back pay calculation works. We talked about front pay. The period of time of front pay can be a year or two. I've seen as much as 5 years. Usually it's not going to be that long. And this would be money that would be awarded to the claimant, to the plaintiff, because the expectation the jury has is that the plaintiff will have a difficult time finding suitable employment going forward. So those are the first two, back pay and front pay. Alternative to front pay is the idea of reinstatement. If the plaintiff is reinstated, obviously there's no need for front pay because he'll earn his paycheck returning to work. Now, reinstatement is an interesting issue. Really, in most cases, neither the plaintiff nor the defendant wants reinstatement. Can you imagine returning to work in a working situation that you were just involved in litigation over? That can't be comfortable for the plaintiff. Similarly, it's not a comfortable situation for the plaintiff's former manager, because probably the jury has found that the former manager violated some law, and now this manager has to face this former employee every day. The manager probably still thinks he did nothing wrong, and so it's a very difficult situation for both parties. So oftentimes front pay is a better alternative, but that doesn't mean that reinstatement isn't sometimes done. Perhaps moving the person to a different department where the whole story isn't known can be one way of resolving that issue. Let's go to our next one. Retroactive seniority. So let's assume that Bob is reinstated. He's going to get he has that 1 year gap of his employment. But typically he will be awarded seniority as if he had had no break in his employment during that time, as if he had continued his employment. So this would affect maybe retirement benefits, or maybe seniority in terms of job posting, or being higher on a layoff list, that type of thing. So that's, here they're calling it retroactive seniority, or I guess I'm calling it retroactive seniority. By the way, these are all okay, the terms you want to do Quizlet. But it's the same thing that we see here with seniority. I guess they list it twice here. But for our purposes, let's just think of it as retroactive seniority. Let's see if I have one for injunctive relief. No, I don't. Okay, so what is injunctive relief? We talked about injunctive relief a little bit earlier. That was when we talked about the temporary restraining order. An injunction is basically just a court order telling somebody to do something or to stop doing something. In this case, it would be the court telling the employer to do something or to stop doing something relating to that employment situation. For example, let's say that the employer discriminated against some workers because of their religious beliefs by refusing to give them time off to attend religious services. Well, then the court could say, I am enjoining you the employer, from prohibiting your workers in the future from participating in religious activities. Now, if the employer violates that injunction, the employer isn't just violating Title VII, the law that provides for religious protections, but it's also violating a court order, which means it's in contempt of court, which means people can start being thrown in jail. And so that's a pretty strong motivation to stop whatever the bad behavior was. Remember I talked before about how many times plaintiffs don't want the EOC to represent them? This is one of the reasons. Because again, if you were one of those individuals who was maybe fired because you insisted upon taking the time off for your religious beliefs, and you don't want to return to that working situation, you may not be that invested in fixing the problem for other workers. I mean, maybe you are a really awesome, nice person who's concerned about other people. But you may also take the view of, hey, I'd pass on this injunctive relief if I could just get a little bit more from pay. Compensatory damages are also available. I probably have one for that. Yeah, compensatory damages. So this is a very broad definition of compensatory damages. I'll give this to you, then we'll talk more about the nuts and bolts of it. And that is, this is the money that's necessary to compensate the injured party for losses that he or she has experienced. Now, this is even though technically back pay and front pay would be considered a compensatory damage, in our area of practice, we don't think of it that way. What we think about compensatory damages are mental anguish type damages. The wear and tear that this has had on the plaintiffs is oftentimes very severe. The devastation of losing one's job, maybe as a result losing one's home, losing one's social status, maybe losing self-esteem. It's not unusual for people to go through pretty significant depression as a result of these types of upheavals. And so that type of mental anguish type loss can be a type of compensatory damages. Then we also have punitive damages, and that is damages that are designed to punish. And you can see at the beginning of the word punitive, the word punish. So they're not designed to make the plaintiff whole. They're designed to penalize the defendant, so the defendant will be less inclined to engage in that bad behavior again, and so that other potential defendants will see what happened to this defendant and say, I don't want that to happen to me. I'm going to stop behaving in that way. So it's a way to encourage better behavior in the future. Typically, the plaintiff gets to keep the punitive damages, even though it doesn't reflect actual damages that he or she lost. We have the make whole remedy. So this is really what all of these damages are. If you add all of them up, with the exception of punitive damages, if you add the back pay, the front pay, the seniority, and the compensatory damages. All of those things, together with attorney's fees and court costs, if you add them all up and you give that money to the plaintiff, he or she is in the same position he or she would have been in if this bad thing hadn't happened to him or her. It's a way to monetize all of the things that he or she has lost. Attorney's fees are part of that, and that is something that you are eligible, a plaintiff is eligible to recover as part of the employment discrimination. Now, this can get to be a little bit complicated because you may be aware that most plaintiff's attorneys don't charge based upon the hour. Instead, they accept a contingency fee arrangement. Typically 30, sometimes as high as 40% of whatever the plaintiff recovers. And so how do we do this, or how does the court figure out what the attorney's fees would be in that situation? Well, typically in the employment law area, even though the plaintiff's law firm is on a contingency fee basis, the attorneys and paralegals in the firm will still be recording the hours they actually work on the case and documenting the type of work they do. And so if they are successful, if they win, they will be presenting a bill basically to the court saying, Your Honor, this is all the hours we worked, these are all the things we did, and these are the reasonable hourly rates that people in this industry with these skill sets that we have would charge for each one of those hours. And so the attorney's fees then would be added to that. So let's say that the plaintiff was able to persuade the jury to award it $100,000. And then the court awards, we'll say, another $100,000 in attorney's fees. So now we have a total of $200,000 in total recovery that the plaintiff has received. We'll assume that there are no punitive damages in this case. Well, then we'll say that it's a 30% contingency fee in this particular jurisdiction. And so $60,000 of that money will go to the attorneys. And then $140,000 will go to the plaintiff. So the attorney will not get the $100,000, the bill that he presented. He'll get the contractual amount that he has in his retainer agreement with the plaintiff. Now, this number can in some cases be larger than this number, or it can be smaller. And then, of course, the plaintiff takes whatever remains. Now, it would be lovely for the plaintiff if the plaintiff were able to keep $140,000. But Uncle Sam, of course, wants his share of the money as well. So in most cases, the amount that the plaintiff actually gets is quite a bit less than the number that we see here as the amount that the company would be paying. There can also sometimes be medical costs, and those would be part of compensatory damages. That's why I said mental anguish type damages, but you could also have some medical costs there if somebody would say were injured at work. Of course, though, that would usually, the workers' compensation statute would usually apply in those cases. Now, I've been talking about compensatory damages and punitive damages, but one thing I haven't mentioned about these is that there is a cap under most of our discrimination laws. Under Title VII, these two amounts in combination for the very largest of employers can't exceed $300,000. And so there's not an infinite number here. Now, there are some ways that plaintiffs can, depending upon how they plead things, can potentially get unlimited punitive damages. Effective plaintiffs' attorneys can be very good at crafting complaints that open up more potential in these areas for higher damages. But these are, for the most part, the most important ones in employment discrimination cases. Now, I don't spend a lot of time in this course talking about remedies because really employers rarely sit back and think to themselves, well, I might discriminate against somebody if I don't have to pay that much. I've never had a client talk that way to me. Clients don't want to violate the law. in the vast majority of cases. I don't mean to say there aren't bad people out there, there certainly are, but the amount that the client is going to have to pay out is usually not directly part of this discussion. Most important, especially large companies, want to comply with the law, and they don't want to pay any remedies, but the amount of the remedies is probably not going to be huge. There are a lot of companies that say, yeah, well, we don't mind paying out a lot of money in these, or we don't mind paying out money in these claims. It's worth us to us if we get to discriminate. So we don't spend a lot of time talking about the variety of remedies in this particular case, because it's not a decision point for most companies. Let's consider the issue of court costs. This should be on the list. It's not. So I'd probably add court costs here. Court costs are usually in the neighborhood of, say, $20,000-ish, and the loser in a case has to pay this to the winner. The court costs are going to be, let me just show you the list of things that oftentimes fall into the category of court costs. Court filing fees, photocopy costs, court reporter fees, etc., etc. The one thing you won't see on this list are attorney's fees. But these are, for the most part, things that the attorneys did pay for. So expenses that the law firm bore can be collected. And probably one of the big ones is going to be the deposition costs. Now, not all remedies are available, obviously, in every single case. So some of the things that we talked about before might not apply. Again, for example, if I've found other employment, a reinstatement doesn't make sense, for example. And then there are cases where punitive damages won't be considered because the facts are not sufficient to justify that. It is possible for a collective bargaining agreement to have an arbitration clause. We talked before about arbitration, and I said how important it was for the employee to sign, to understand the agreement, and to, on his or her own, to decide to sign. That's true in most arbitration agreements. But in the case of a collective bargaining agreement, and this is in the union context, the workers together negotiate with the employer to come up with the terms of this agreement. Well, as you can imagine, if you have a group of people, not everybody's going to agree with every single term in that agreement. And so there's going to be a vote, but it's majority rules. If I happen to be someone who didn't like the collective bargaining agreement, of course I can quit. But if I decide to stay, and I'm going to be bound by it, even if I don't agree with the terms. And that does include an arbitration clause that might be part of that collective bargaining agreement. Whether I have an individual arbitration agreement or there's an arbitration clause in collective bargaining agreement, under either one of those circumstances, I can contract away my right to go to court over this dispute. But what I can't contract away is my right to go to an administrative agency to complain about discrimination. Again, this is a public good. This is something that helps the larger society because the EOC can investigate that and pursue solving that problem in that workplace. It's a little bit like me calling the police when I've been robbed, or me contacting the FBI when I think there's been a kidnapping. I'm alerting the law enforcement entity about a problem. And so a contract can't preclude a person from doing that. Let's consider this scenario before we wrap up this presentation. So we have Mary. She's a manager for Badger Industries, and she had a very good reputation, very high appraisal ratings in her place of employment. She gets a new supervisor who seems to think women aren't smart enough for this type of work. Shortly thereafter, she is fired. If she's let's say she files her lawsuit and she's successful in her gender discrimination claim, she can get the back pay, and she can also potentially get reinstatement if she wants to come back. Or, as I said, if not reinstatement, she can get front pay. So that's an example about how the remedies work. So thank you for your attention. When we're together next, we will talk about what roles human resources managers and legal department have in the area of employment discrimination. And thanks for your attention. I hope you have a wonderful day. Take care.